The last thing I think that's so critical here when we examine this issue of torture and understanding why it is that the public and Congress seem so anemic in responding to these blatant violations of law, I think it exposes a very ugly undercurrent in the United States culture that they see the names who are the victims, Boumediene, they all sound Arab, foreign, Muslim. It's not Smith and Johnson, so who cares? These are the bad guys. Even the discussion of the Guantanamo Bay detainees who haven't been charged and convicted of anything. They're all terrorists. They can't come here. We need to do everything we can against them. Well, they actually haven't been charged with anything. Why are these assumptions being made? And I think this is an underlying bigotry against Islam that paints this entire discussion. And that's what distinguishes, in some sense, Watergate, where you had Daniel Shore's people in the regular news media who were the subjects of the enemies list. But if we're going to show ourselves and our character, we need to extend the benefits to all human beings because they're human. And torture is the fundamental standard of civilization and lawlessness. And I think we're failing on that score at present. Thank you.
Okay. We'll take questions after all three of us speak. Our next speaker, Shahid Buttar. Shahid is a graduate of Stanford University Law School in 1983. He is an activist who's spoken out greatly on constitutional law issues, on justice issues, on free speech issues. He's currently the executive director of the Bill of Rights Defense Committee. Shahid.
Thank you, Kevin. Thank you all for being here. Just one slight correction. It wasn't 1983, but rather 2003. But I'll take the time. No, it's good. I have enough grade to indicate that I may have been. I appreciate you all being here this morning. I'm going to talk primarily about three things. The first is transparency and how it's implicated in the debate about torture accountability. The second is legitimacy, and I'll address that in a couple different contexts, but the novel one that you may not have heard before, relating particularly to our domestic criminal justice system. And then some final reflections on the implications of torture for other policy areas going forward. And this is also an area in which I think the existing discourse has really contorted the reality and overlooked some of the very fundamental things on which we should be focusing. So first, with respect to transparency, prosecution for torture is necessary for us as a society to know what happened. And transparency is a prerequisite to the operation of any of our democratic checks and balances. Courts cannot assert judicial review and oversight through that process without transparency. Congress cannot act either legislatively to stop offenses going forward, and its oversight is diminished when there's not transparency into what the actual acts were that were committed. Now, there are two areas with respect to transparency that I think have come up that have failed to receive the attention I would say that they deserve. The first is the destruction of the tapes of interrogation maintained by the CIA. And the second are the set of secret photos that depict rape of detainees by U.S. personnel. So the latest flip-flop, let's say, or two-step with respect to the photos was the administration, after initially committing to disclosure and then being ordered by a court to disclose the photos, then coordinating with Senators Graham and Lieberman to shut down the Senate by insisting that the first legislative act by the Senate be one to prohibit the disclosure of these photos, basically to congressionally give the White House cover to maintain executive secrecy. And I just invite you to put that in the lens of what Bruce was talking about in terms of interbranch checks and the rule of law. With respect to these photos, if they're not disclosed, how do we know exactly what abuses we may or may not be prosecuting for? And without knowing that, how can the debate around prosecution have any legitimacy? How do we take comfort, for instance, in the reluctance to prosecute when the extent and scope and scale of the prosecutable behavior remains unknown? The argument's been made that the disclosure of the photos would harm American interests, that it would place our troops abroad at risk. But I'd invite you to consider two overlooked premises in that construction. The first is it the disclosure of the photos, or is it the conduct depicted in the photos that places our troops at risk? And if it is the latter, if it is the conduct, if it is the torture and the rape that these photos allegedly depict, is that not a basis for prosecuting its conduct rather than sweeping the evidence under the rug? Does disclosing the photos and prosecuting the people responsible do a better job of protecting our international legitimacy? Does it do a better job of promoting the rule of law principles that as a society we have long defended and promoted, pioneered in fact, or does sweeping the evidence under the rug in order to hide what everyone already knows, that torture was committed by U.S. personnel at Guantanamo Bay, at Bagram Air Force Base, at Abu Ghraib prison, where else one might guess? CIA black sites? Except we don't have transparency into those either. Okay, setting aside transparency and moving into legitimacy. I want to address this in three different contexts. The first, and I'll just make a reference to this, is the grand sense, the rule of law sense that Bruce was unpacking for us a minute ago. The second is the international legal regime. I published an op-ed over the weekend discussing in particular the Nuremberg precedent and the extent to which a seminal, uncontroversial, fundamental principle that our own Supreme Court Justice Robert Jackson declared as some of his most important work was establishing this principle that up and down the chain of command, regardless of the assurances of any set of domestic laws, some set of actions, war crimes, violations of human rights, are criminal. It doesn't matter what OLC said. It doesn't matter what lawyers gave whom what confidence that their actions were legal. The Nuremberg cases stood quite clearly for the proposition that some laws transcend those of any nation, including our own. It is a grave travesty that we have now found ourselves challenging the basis for those principles after having done such world historical work, I think, in promoting them. The second area, or the third, I should say, in which legitimacy is threatened, and this is one I think in particular I haven't heard anybody talk about, and it astounds me, is the legitimacy crisis facing our own domestic criminal justice system, when on the one hand, nonviolent crime is prosecuted without inhibition. There were over 300,000 prison sentences imposed in 2007 and 2008 for nonviolent crime around the country, when torture, which is intentional violence for the purpose of inflicting pain, goes unpunished when it's committed by politically connected senior officials. That is a legitimacy crisis. There is a profound tension in the pro-prosecutorial bias in the one context and the anti-prosecutorial bias in the other. Just last week, the Bill of Rights Defense Committee, which I lead, submitted to the Attorney General, as well as members of the Intel and the Judiciary Committees on the Senate side, a series of letters on behalf of 4,000 Americans noting this particular tension. 500 teachers talking about how for them teaching the civics narrative was becoming untenable because their students wouldn't accept it. They see the school-to-prison pipeline on the one hand, imprisoning their peers, and then they see Dick Cheney and his enablers, on the other hand, getting off scot-free for much, much, much worse behavior. And the last, I think, issue here that I'd like to talk about are the implications of accountability for torture. You're all familiar, at least in the abstract, with the proposal for a preventive detention scheme to circumvent the Article III courts and create a new system of unequal justice for national security cases in the United States. That we are even considering a proposal along those lines is not only a betrayal of our nation's most fundamental values, any number of constitutional provisions, and our own international historical legacy, but it's a function of the political climate being conditioned by the people who enabled torture in the first place. The reason we're talking about preventive detention is because instead of being behind bars, Dick Cheney is in front of a camera, quite frankly. And as long as criminal charges, appropriate criminal charges, legally necessary, mandated criminal charges, don't face the actors who enabled and authorized and committed torture, the policy debates going forward on not only torture, but detainee policy, other seemingly unrelated policies in the war on terror, like perhaps the domestic surveillance regime, all of these policy debates will be skewed, stilted, tainted by the participation of political actors who were both politically rejected at the polls and now given get-out-of-jail-free cards for what seems to be criminal conduct. The Bill of Rights Defense Committee supports the appointment of a special prosecutor, at the very least to investigate what happened, who is responsible, the application of our international treaty commitments, our own constitutional commitments, statutory violations that may have been committed. We owe it to ourselves as a society, and the legitimacy of our own institutions depend on conducting a thorough, independent investigation, prosecuting where warranted, and bringing to justice those who are responsible for violating our nation and the world's most fundamental commitments. Thank you.